All right, good evening. My name is Anita Seghetti. I'm LAMDA's president. You cannot see me right now because I'm involved in a beauty emergency, but I will be with you for the group photo that we will take at the end of the session when you'll be asked if you're able to turn your camera on so that we can do a group photo for social media and so on. So welcome to today's third part in LAMDA's CCB CPD series. Those of you who have been with us throughout will know that there was a part one, which is a video recording as an introduction to the practice before the Consent and Capacity Board that I did with Shira Brass, who's also a member of LAMDA. Part two featured another two women, Naomi Sayers and Danielle Lee Chong, talking about capacity to make treatment decisions and litigation around that before the Consent and Capacity Board. Today is part three, when we have the first and second and third and fourth of the men who are participating as part of the organization committee and your presenters for this series. Part three will cover today involuntary admissions and Form 16 applications to the Consent and Capacity Board to review an involuntary status of a patient applicant. We are recording this session. The recording will be made available to registrants later on. There are some materials with respect to this session, including in particular case that was circulated earlier. I think the initials are MAT. Your fact scenario will be based on that. And with respect to CPD hours, this session will qualify for an hour and a half of substantive CPD, but we are also intending to make an application that hopefully will be approved retroactively for some professionalism and some EDI hours. If you have a question, we are likely to hear those questions at the end. We're aiming to reserve about 15 minutes at the end for your questions. You can also drop them in the chat and we'll monitor for that. So with all of that, I guess I should just briefly introduce Michael Schloss is an associate in my office. Mitchell Rowe is senior counsel extraordinaire in Ottawa as a significant Consent and Capacity Board practice. Michael French is also senior counsel here in Toronto, I think, who does pretty amazing work, and LAMDA members will know them all as frequent contributors to our listserv. And Shanil Patel, a young lawyer who also practices in the area, and we're grateful to have him assist us in organizing, moderating, and presenting for this session. So welcome to everyone. With that, I hand it over to Shanil. Thank you.
Thanks, Anita, and hello, everyone. Welcome to part three of the LAMDA CCB CPD series. And in this session, we will be talking about matters before the Consent and Capacity Board, where an individual is fighting their involuntary status at a mental health care or psychiatric facility. As Anita said, I'm Shanil Patel. I'm a mental health lawyer in Toronto, handling primarily CCB Section 3 and guardianship matters. I will be moderating today's discussion. And as Anita said, each of you should have received a case involving a patient called MTA, who was challenging her involuntary status at CAMH. That case will form the basis of our mock cross-examination today, and we'll be discussing it a little bit. So if you have not received it, we can put it in the chat if there's anyone that has not received it. I'm going to also introduce our panel members. We have Michael French, who practices before the Consent and Capacity Board. He has his own practice called French Health Law, and he'll be discussing Box A and Box B criteria today, which are the central issues in most involuntary status cases. We have Michael Schloss, who practices also before the Consent and Capacity Board. Regularly, he works with Anita. He will be discussing the unique client issues that pop up in involuntary admissions matters. We have Mitchell Rowe, who's a senior member of the bar. He practices civil and criminal litigation in Ottawa with years of experience in mental health law. He'll be conducting the mock cross-examination based on the MTA case that was handed out. And although each of our panel members are going to be covering a certain topic, they may jump in on other topics if there's a question that they have something to add to. And again, we will leave time for questions for the panel at the end. I'm going to do a quick land acknowledgement. We acknowledge that the land we are meeting on is on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. I'm going to start off by introducing the topic of involuntary status hearings by providing some context, because I recognize that maybe not all of you are familiar with this kind of work before the Consent and Capacity Board. When we're talking about involuntary status cases, we're talking about cases before the Consent and Capacity Board where a patient is challenging their involuntary status at a psychiatric facility under the Mental Health Act. To give context to involuntary status cases, a patient in a psychiatric facility may be considered voluntary, they may be considered informal, or they may be considered involuntary. And a voluntary patient has the right to leave a psychiatric facility. An informal patient typically has a right to leave, but it is subject to what a power of attorney document might say and other matters. An informal patient typically has a right to leave, but it's subject to what certain documents might say. An involuntary patient typically cannot leave the facility without permission from his or her doctor, and doing so may lead the police to bring the patient back to the facility. These cases typically involve a patient who exhibits signs of a mental disorder being brought to a hospital, either voluntarily seeking assessment or involuntarily, for example, by police, either with the authority of a justice of the peace or without such authority in certain emergency situations. The justice of the peace may order that a person undergoes an examination, or a physician may apply for the patient to undergo a psychiatric assessment by filling out a Form 1. The Form 1 authorizes detention for up to 72 hours at a psychiatric facility. And even though there's no right to apply to the board at that stage, the person must be given written notice of the Form 1's issuance for reasons of the detention, for the detention and of the right to retain counsel. If the person has not been admitted to the psychiatric facility before the 72 hours are up, they must be discharged. If a voluntary patient or an informal patient or a person subject to a psychiatric assessment under a Form 1 meets certain criteria, which we will get into later in this presentation, they may be made an involuntary patient by filling out a Form 3, or a Form 3 will be filled out by a doctor. This is where they may apply to the board to challenge their involuntary status, which, as Anita mentioned, is Form 16. They may also apply when their involuntary status is renewed, a Form 4 or a Form 4A for subsequent renewals and continuations. The patient may fill out an application to challenge their voluntary status again at those stages. So there is a tendency in this area of law for lawyers to start to act towards what they believe is in the person's best interests rather than what the person is instructing you to do. And one of the things I think we're trying to emphasize with this education series by LAMDA is that the role of the advocate in this area. And it doesn't just change because your client has mental health issues or challenges, or that they act centrally, or that they may give instructions that are apparently contrary to their own interests. I find it helpful to think about what's at stake for these clients and the person that you're representing on an involuntary status case. For one, they've probably gone through a humiliating experience, such as being ordered to go through an assessment or being taken in by police. If they do not win the hearing, which is fairly frequent, or probably more times than not, they end up not winning, they may be further kept against their will at a psychiatric facility without the ability to challenge their status for 2 weeks to 3 months, depending on how many renewals or continuations there have been. It is also important to remember that the onus is on the physician to prove that the patient continues to meet the criteria for involuntary status at the time of the hearing. Those criteria are known as the Box A and Box B criteria, which are found in different iterations throughout the Mental Health Act, but for our purposes, it's section 20 sub 5 and 20 sub 1.1. And I will now be turning to Michael French, who will be discussing the box A and box B criteria.
Thanks,
So,
Shanil.
hey, Michael. My first question for you is, in what context do we see the box A and box B criteria in the Mental Health Act?
Elaborate on what you mean by what context.
So where does it appear in terms of not only the involuntary status admissions, but does it appear in other areas, such as when you're bringing the person into the hospital, or if there's reason to believe that the police should be involved?
Yeah, I mean, you see some of the criteria in Form 2s that perhaps a family member may come and get and go to a justice of the peace to have someone brought to hospital. You see much of the criteria in a Form 1, so the precursor to a potential Form 3, where somebody's being held for 72 hours. But as you said, I mean, the criteria come straight from the Mental Health Act.
And in order to be considered involuntarily admitted or under involuntary status, what grounds does the patient need to meet? Box A and box B, box A or box B? How does it work?
Yeah, so I mean, it can be either. In regard to box A, I mean, there's of course 3 criteria. There is serious bodily harm to oneself, serious bodily harm to another, and serious physical impairment. And you know, the criteria is at the time of the hearing whether that is likely. And for certain individuals who have a history of hospitalizations and who have benefited from treatment in those hospitalizations, I think the word is clinical, have clinically improved with the treatment, they may be eligible to qualify for the box B criteria.
And so starting with the box A criteria, can you tell us again, what exactly are the box A criteria?
Sure. So the box A criteria are serious bodily harm to the patient. And do you want me to explain a bit of how that's interpreted by the board?
Sure. Or you know what, we could probably get there, but let's start with the whole test and then we can break it down.
Sure. So the box A, I mean, serious bodily harm to the patient, serious bodily harm to another person, and then serious physical impairment of the patient. Those are the 3 box A criteria.
Okay, and just important to note that the person has to be suffering of a mental disorder of a nature that those things will be, that will likely result in bodily harm, serious bodily harm to another person, serious physical impairment, and that the person is not suitable for admission or continuation as an informal or voluntary patient.
That's right.
That's okay. And the physician, do they need to prove all 3 of these or one of them? How does it work?
No, it can be just one of them. I think they can rely on all 3. They can rely on 1 or 2. And oftentimes, what you see is at the beginning of an admission, the criteria you may see on a Form 3 changes. So the test is at the time of the hearing, and so oftentimes a doctor will rely on different criteria at the time of the hearing. That may be because somebody has improved and no longer meets a certain criteria. It may also be that they've exhibited behaviors or collateral information has been received that means that the doctor now feels that they in fact meet other criteria that weren't originally relied on.
Right. And in terms of a mental disorder, what are some examples of the types of mental disorders we see in these patients?
Yeah, so I mean, I think common ones that we tend to see would be bipolar disorder, schizophrenia, schizoaffective disorder. You know, I'd say, you know, major depression is one you'd often see. But certainly disorders that you sort of characterize as mood disorders or psychotic disorders would be the most common.
Can drug use be considered a mental disorder or drug addiction?
You know, it's a bit of a contentious point, Shanil. I mean, certainly substance use disorder has been characterized by the board as meeting the criteria for a mental disorder. However, I mean, it can be argued that somebody using using drugs on one occasion and having to be hospitalized for a short period of time, if a doctor is looking to rely on box B criteria, you might not be able to say that that is consistent with the current treatment that they're receiving, that falls short of treatment for the mental disorder.
Okay, now moving to the criteria in terms of risk of serious harm or impairment, which is the first part of box A. I think an important qualifier is the word serious. So, for example, what is, as a result of a mental disorder, what would result in serious bodily harm to the patient? Do you have any examples?
Yeah, so I mean, serious bodily harm to the patient is it's really looking at intentional self-harm. So you'd often see, a risk of suicide being captured here. And when I say intentional, it's because it's distinct from unintentional harm to self, which would be captured by serious physical impairment. So I think, you would see somebody who has perhaps active suicide attempt, who has a plan to follow through with that, who's been brought into hospital. I mean, that would be quite a common one.
And again, with serious physical impairment, because it is difficult to sort of parse these, can you explain again the difference between serious bodily harm to the patient and serious physical impairment to the patient?
So serious bodily harm to the patient, it again goes back to intent. So is it that somebody is doing things that could lead to intentional self-harm, whereas serious physical impairment is looking at the unintentional, that somebody may, as a result of their mental disorder, be putting themselves in a risky situation or a position of peril that they are not intentionally putting themselves in.
And in terms of what is considered serious bodily harm to another person?
Yeah, so serious bodily harm to another person, I mean, it's been characterized as harm that is more than trifling. There are several, and with much of this area law, I mean, it largely depends on the decisions you read, but it can capture psychological harm as well. For instance, I mean, you'd see that it's been held that somebody throwing an object at a nurse that caused a broken nose met the criteria for serious bodily harm, whereas it was not met in an instance where someone had slapped their child and it didn't lead to any injuries and there was no treatment, for instance.
And what kind of evidence is considered in determining whether the mental disorder will likely result in serious bodily harm to another person?
So, I mean, they can consider all evidence. So the board's able to consider hearsay, but they're supposed to weigh it appropriately. They'll look at how the individual is presenting in hospital, and they will take that and also look at their history. It doesn't necessarily mean just because somebody hasn't in the past committed an action that would be considered serious bodily harm, it doesn't mean that criteria can't be relied on. I think as counsel would be persuasive to point that out, that such harm has never occurred. But the doctor is able to consider any evidence. So that may be evidence directly from the patient, it may be from previous medical records that they've observed, maybe from their own observations in the hospital, maybe from collateral sources, oftentimes family members.
Right. And what you said there is one of my favorite cross-examination questions to ask a doctor is there's never been actually any physical harm that the patient has caused. And that's a good one to keep in the back pocket. When we're talking about whether a patient is not suitable as an informal or involuntary patient, how is this determined? What is usually what do you usually look at in terms of that question?
Again, Shanil, it's a bit tricky. You get into areas of sort of circular logic, and that somebody is suitable to be a voluntary patient if first they're willing to stay as a voluntary patient. There's been conflicting decisions on whether staying means that they need to be receptive to treatment when they stay. I think logic would infer that probably should be the case. And ultimately, if somebody indicates that they would be willing to stay, and the doctor feels as though they do, genuinely are suitable to stay, then they can be made a voluntary patient. The issue, of course, is that part of the suitability to stay is the willingness to stay. And so if somebody right after being made a voluntary patient tries to be discharged from the hospital, which would usually be their right, that may suddenly make them unsuitable as a voluntary patient. And you often see somebody who is reformed as a result.
And there's one more aspect of the test. So will, for example, cause serious bodily harm to another person or serious physical impairment to themselves or serious physical or serious bodily harm to themselves unless the patient remains in the custody of a psychiatric facility. In your opinion, what does this phrasing add to the criteria or to the test?
So in my mind, it adds perhaps a level of acuteness that if discharged, what would one anticipate to see in the community? So, the thought is that if somebody is leaving the hospital and that, they're going to be in the community, it brings into light that there is a different environment than the hospital environment. The hospital environment is at times a controlled environment, that you don't see the same variables, and there may be an exacerbation in the community. And again, I think it raises the fact that the presentation of an individual in the hospital isn't necessarily determinative of exactly how they will present in the community.
Okay, let's move on to the box B criteria. Michael, what are the box B criteria?
Sure. So the box B criteria are replicated from the box A criteria, but yet you have the additional criteria of substantial mental or physical deterioration that you don't see in the box A criteria.
And box B is a newer criteria that was added into the Act. What does the box B criteria do and meant to capture that the box A criteria does not?
Yeah, so I mean, the box B criteria is looking to capture the quote unquote revolving door patient. It's indeed a newer criteria. It came in with Bill 68, which is Bryan's Law, which I think is often thought of in terms of community treatment orders. But yeah, it introduced the box B criteria and took away the requirement for imminence in box A criteria.
In the box B criteria, we see some of the same language from box A, for example, serious bodily harm to the person or to another person, serious physical impairment of the person. And as you mentioned, we do see some other criteria, namely that the mental disorder, when not treated, will lead to substantial mental or physical deterioration of the person. What's the significance of the inclusion of this other criteria?
It is, I think, as you pointed out, quite a significant inclusion in that it means it's a standalone criteria. It essentially means that if you were to take somebody's psychiatric baseline, if they fall well below that baseline, to the point that that is in fact significant, that they will be able to be hospitalized as a result. In that, when I say standalone criteria, I mean that it doesn't mean that somebody's mental health falls below baseline, and that means that that their behavior will tie into serious bodily harm to another, or serious physical impairment, serious bodily harm to oneself. Again, it's a standalone criteria, so it takes into account their history, and essentially, I mean, the wording is often you see in the cases that it has to be considerable, consequential, ample, significant, sizable, and so it's a change in one's functioning or symptoms that is a significant decline.
Right. Part B or sub B of this criteria, we see that it requires that the patient showed clinical improvement as a result of the previous treatment. Is there any way you would qualify this?
Yeah, I mean, certainly when you're looking at it, you're going to want to see that the mental disorder that's being looked at is the same or similar. In that, if somebody is now being admitted and the diagnosis is schizoaffective disorder, they're being treated with an antipsychotic, and the physician is trying to say that they've clinically improved with treatment, and that this is the same or similar disorder, but their past admissions were for delirium stemming from diabetes, where a medication was taken that was altogether dissimilar. You're going to want to look at that.
Okay, that's an interesting point about the mental disorder being the same or similar. How does the board determine whether a mental disorder is similar as the previous one treated?
So much of it is looking at the symptomology. I mean, I think there is an understanding and acceptance that when somebody first presents at the hospital, that there won't necessarily be a diagnosis when they walk in the door, that sometimes they evolve, and it's a matter of looking at the symptoms and suggesting whether what one is seeing today is similar to what they're seeing previously. I think as counsel, you often or almost always want to get discharge summaries from previous admissions, so you can see, in fact, what the discharge summaries indicate that the diagnoses were, and what the medication was, and whether they in fact found that they improved as a result of the medication.
And Part E requires that if the individual has been found incapable of consenting to treatment in a psychiatric facility, the consent of the substitute decision maker must be obtained. And how does this figure into preparing for the hearing?
Well, I mean, first you're going to want to check the record, see who the substitute decision maker is, and then logically see if they're the appropriate substitute decision maker. You can look at the hierarchy of decision making to do so. You're going to want to see if the substitute decision maker's consent was informed consent. So whether the physician reached out to the substitute decision maker and explained what was occurring, and gave them appropriate information so that they could make an informed decision. It also means at times that at the hearing, this individual may, more common than not, perhaps present and be a witness to support the doctor's position. And I think you need to be aware of that and have questions ready in order to be able to push back against some of the evidence you can anticipate them bringing forward.
Great. About to move on to client management, hearing preparation, but Michael, is there any other thoughts you have about Box A and Box B criteria before we move on?
No, I think that's I think that's very good. And again, I'd highlight that it's difficult. Many of the concepts are not defined in the Mental Health Act, so you really have to look through the cases to see how the board has decided these issues and what meets the relevant thresholds. Not to pander, but I think Anita's book is a pretty good starting point in that she has lists out the various criteria and has cases over the various years and what has met and what has not met the relevant criteria.
Feel free to pander away, pander more.
So yeah, that's all I have, Shanil. Thank you.
Thank you, Michael French. And Michael Schloss, I'll be talking to you about client management and hearing preparation in these types of files. Michael, how do your involuntary status files come in? Where do you get those files from, and how do they first get to your desk?
So calls from rights advisors is probably the largest source we have. So it's important to cultivate a good relationship with rights advisors so they know your name and can refer cases to you. There's also a listserv for CCB cases run by Legal Aid, which sends out requests for counsel on cases a few times a day. And of course, repeat clients is another source of cases. When patients meet with a rights advisor, they can request a specific lawyer, so we get calls from them that way.
Great. And one thing that's really important to keep in mind when you take on one of these files are the deadlines, because they're quite tight. Can you tell us about what the deadlines are in these cases?
Well, the CCB is supposed to schedule a hearing within 7 days of receiving the client's application. So there is a pretty rapid turnaround. And in all cases, we say that the client's hearing needs to be heard while the form is still active. Actually, it needs to be heard and decided while the form is still active. Otherwise, it's considered to be a judgment on the following form. As far as deadlines, any documentary evidence that is going to be relied on in the hearing is due the day before it. The doctor has to submit their evidence by 10 a.m. And we have to submit ours by 2 and also give written notice of any preliminary issues we're raising.
And in terms of your clients, when do you first try to speak to your client in these types of cases?
I like to briefly speak with my clients fairly soon after we get the referral, especially if they're on a Form 3, because that's the first time they can challenge their admission. And our clients are in an upsetting situation, and I want them to know that someone is looking out for them and sort of fighting for their rights, right, as close to the beginning as is feasible. I will typically say that I just received the referral and haven't had a chance to start working on their case much yet. So I'll try to keep that conversation fairly brief and say that I'll call them again so we can talk in more detail a little closer to their hearing.
And so again, what you just said is interesting because often the first time you get the file within the first day or so, you might not have much information at all. And often not until the doctor submits their information or you get some records from the hospital. Do you ask your clients anything immediately? Is there any pressing questions that you need in the first time you speak to them? Or do you wait until you receive some more information before you start to build the evidence or build your own story?
Well, some hospitals we know that will receive the evidence or receive the documents from them within a day of our application. So sometimes I will sort of delay a day until I have that. But if we're not sure, I'll always ask for their story about what happened that led them to being brought to the hospital, or admitted to the hospital, just to hear it from their perspective of how they see things. And I'll ask about previous admissions and medications and how they see their mental condition. And also just generally what their doctor has said to them since they've been in the hospital.
And how do you explain the hearing status or the hearing process to clients facing an involuntary status, hearing the consequences, et cetera, what to expect? What do you usually tell them?
Well, I'll describe very briefly how the form they're on works and what the criteria the doctor is relying on mean in terms of what the doctor's concerns are, why they're there. For the hearing itself, I'll explain the sequence of events that happen during a hearing, like start with introductions and then preliminary issues, if there are any, the doctor's direct evidence, my cross-examination, et cetera, et cetera. And I'll explain that the board will make their decision within 24 hours of the hearing. They won't give a decision right at the hearing, typically. But within 24 hours, we'll have the decision and we'll know whether they have to remain for the rest of the period of their form, or whether they'll have to be released as soon as possible. And how I really tailor it to the client, their level of education, their mental condition at the time, and generally try to use plain English rather than technical terms like preliminary issues.
Right. And you've been over this a little bit, but I'm just going to ask to make sure if you have any other tips. You mentioned the state of mind the clients are in when they are in this type of hearing. They're usually uneasy or scared. Maybe they feel a little bit indignant. They don't know what's going on. They don't feel like they deserve something. They deserve what's happening to them. How do you go about building rapport with clients in these types of cases?
I think the most important thing is to really listen to them and listen to what they have to say and empathize with their experiences, especially when first speaking with them, even if a lot of what they have to say isn't directly relevant to their form and your legal representation. I think it's important to build that connection with your client, and also to sort of give your impression about how they're feeling and just validate their experience.
What kinds of documents do you usually request from the doctor or the hospital in particular in these types of cases?
Well, We typically request everything from the client's first current admission, as well as the discharge summaries from their previous admissions. I mean, we have a standard form that basically lists every kind of medical record and all the legal forms to sort of list all the possibilities, because we don't want to exclude something that might be in the hospital record that'll help our client, because different hospitals organize their files differently. So if we say we don't need like medication notes from one client, because typically they're just long charts of numbers. In some hospitals, that might exclude sort of nursing notes relating to medication. So we want to make sure we capture everything.
And what are you looking for in the documents that you receive when you're reviewing those documents?
Well, the first thing I look at typically is the admission summary and any emergency department notes, because they typically have a good overview of the client and their history and why they were admitted in the first place. Then I look to the legal forms and other documents that show sort of procedural compliance, and that could be the basis of a preliminary motion. Finally, I look throughout them for evidence on box A criteria always, because you can never be 100% certain that it's not going to be an issue. And then box B criteria if it's applicable. So I look at like, I mean, Michael French covered them all, but I look at sort of previous admissions, whether they've actually improved from previous treatment, and whether any consequences that could be reasonably expected are serious.
Right.
Yeah.
And that is a good point. You can't apparently go off just what the doctor is relying on. As you'll see in the case that we handed out, you should prepare for all scenarios and all criteria too. When you are preparing for the case, do you ever attempt to speak with the treating doctor or psychiatrist, or reach out to them? And if so, if there's an advantage to that you see?
I do only rarely. I mean, aside from scheduling and possible adjournment issues, the one situation where I do reach out to the doctor is when the client's saying they're willing to stay in the hospital voluntarily. They'll say, I don't mind being here. I'm fine staying here for a while. And then I'll email the doctor and say that a form can't be maintained if the client is willing to be a voluntary patient.
Right. And in terms of preparing your client for the hearing itself and how to behave in the hearing, what advice do you give your client, or tips that you can give our audience today on how to prepare your client to behave in the hearing?
I think the single most important thing to tell our clients is that in the hearing, it's very important that only one person speaks at a time, and that each person gets their turn to talk in a specific order determined by the board. I tell the client that they should not ever interrupt or say anything during the doctor's evidence or while the board is talking. Basically what I say to them is that the doctor may say things that you disagree with, or even that are not true. But I'll be cross-examining the doctor on their evidence when it's my turn to do so. And if there are things you want me or the board to know, then I advise the client to take notes during the doctor's turn or during other evidence. And that way, if they choose to testify at that, after the doctor's evidence, then they can give their side of the story. Or I can bring it up once I have a chance to learn that from the client in my submissions. But just interrupting doesn't help, and it can even hurt the client's case.
Yeah.
And I think it depends on the client. Some are more impulsive than others, but when it is a concern, I definitely bring it up a few times.
Yeah, yeah. And you can't always help it. Sometimes it just happens very frequently. In involuntary status cases, what is your breakdown, I would ask, about the amount of clients you would recommend that they testify or give evidence, and the ones that you'd say should not give evidence? You have to give a percentage to it.
For involuntary status hearings, I'd say almost never. I mean, there's rarely a situation where something the client can say in evidence would outweigh the risk that they might be asked difficult questions, or even that will be helpful. If a client, well, if a client says they'll be safe and be on their best behavior if they're discharged, that may not even help, even if they go into detail, because if the doctor contradicts that and says that they'll act impulsively or they might relapse to substances despite their best intentions, their contradictory statement doesn't help much. There's a few situations where it can be very helpful, such as if we need evidence about where the client is going to live if they're discharged, so the board knows they're not just discharging them to the street. Or if there's some context or important background to the events leading to their admission, that can't be brought out in documents or cross-examination of the doctor. And occasionally, if the client presents as being very well, and it's a big contrast from how they were described as being when they were first admitted, that can be helpful. But again, there's always the risk of what could be brought out in cross.
Exactly, yeah. That they could be goaded or that they could be rubbed the wrong way too, right?
If it's a case where the form is almost certainly going to be informed by the board, then in those circumstances, I'm less likely to strenuously oppose the client testifying if they really want to, just because that it can't hurt much. And at least then they'd felt heard and felt sort of that everything they wanted to say was said to the board.
That's another interesting point. So in cases, which are the vast majority, where you recommend your client does not give evidence, how do you go about making sure that they feel heard?
First, when I'm speaking to them, I take time and I listen to them and accept what they say, just so they know that I'm at least hearing them. I also pay particular attention to what they consider the most important, like the side effects of the medication is a common one, or some circumstance of their admission that they find unfair. And I'll put that in my cross-examination questions or in submissions, if it doesn't hurt the case, of course. So in essence, I'm telling a tailored version of the client's story that they want to be heard on their behalf, so that at least they know that that's out there.
And are you ever able to find witnesses who help you out with your client's cause, or is that also fairly infrequent?
Yeah, it's rare. In practice, most family members and other possible witnesses typically want our clients to stay in the hospital until they're totally recovered. So once you factor in the doctor and panel members' questions, their testimony might be more harmful than helpful. It's more common for us to be cross-examining witnesses brought by the doctor, like a family member or a friend or roommate.
Right. Finally, when the case isn't won, or if you lose the case, what do you inform your clients about the right to appeal the decision? What are the decisions that they need to make and the things they need to weigh in deciding to appeal the decision, and the timelines, et cetera?
Well, I tell them that as a rule, I'd never recommend any appeals for involuntary admission decisions. And that's because appeals take months. And while the appeal is pending, the client has no right to any further review from the board. So they could be kept in hospital for the entire duration of the appeal without being able to challenge it at a CCB hearing. In virtually all circumstances, it's quicker to just wait until the client's form expires and get a new hearing on their next form. Even if they're on their third Form 4 or Form 4A, which lasts 3 months, that's still quicker than getting a decision from an appeal. Now, I haven't personally had a client insist on appealing after being told about all the consequences. But if they do, it's important that they know that there's a very short timeline for filing the notice of appeal. It's like seven days from the date you receive the decision. And also that they have a right to request written reasons for the decision. And there's also the issue of funding, and they may be unlikely to receive funding even if they do appeal.
Yes. And even the right for written reasons has a deadline. I think it's 5 days or something like that. You have to request it within the decision. So
30.
30. Okay. Yeah. So it is still pretty quick. Long story short, they got to act quickly if they do decide to act on the appeal. Okay. Thanks, Michael. Do you have anything else to add, or should we move on?
No, let's move on then.
Okay. Thank you so much, Michael.
Thank you.
Okay, so we're now going to move to our case study and cross-examination. And the case we handed out, as I mentioned earlier, it involves a patient called MTA who's challenging her involuntary status at CAMH in Toronto. And we thought this case would be interesting for two reasons. Firstly, the evidence supporting involuntary status is fairly overwhelming. It's not uncommon in these types of cases, and a lot of these types of cases that we fight before the board. As with the case with MTA, an applicant before the board may have an extensive history of hospitalizations due to mental health issues, and the doctor may have a solid case on multiple of the risk factors enumerated under Box A and Box B. And as we will see with Mitchell's cross-examination, there is still a lot of advocacy to be done and a lot of questions to be asked to the doctor. Secondly, and I'll highlight this quickly, there was an interesting legal issue that popped up in this case. Basically, the applicant argued that if the board found that the Box B criteria were not met, which they were in this case, but if they were not met, then the board ought not to consider the Box A criteria, because in the Form 3, the doctor only referenced the Box B criteria. The board noted that it was settled law that if a doctor is relying on Box A grounds, the grounds could change to Box B grounds by the time of the issuance of the certificate, by the time from the issuance of the certificate to the hearing. But the narrow issue here is whether it could go the other way, whether in the circumstances of this case, the Box A grounds could be relied on when the Box B grounds were only the ones referenced. In the circumstance of this case, where much of the cross-examination had to do with the Box A grounds and the CCB summary had to do with the Box A grounds, the board determined that it could consider the Box A grounds, and it indicated that generally it has an obligation to inquire as to whether any of the grounds for involuntary status are met. However, it did say that its reasons are not likely to be the last word on the subject, so it's perhaps open. I think many of us would say this is maybe wrong in the results, but it's not hard to see both sides of the argument. On one hand, the onus is on the physician, and the patient should be informed about the grounds for their detention. On the other hand, the Mental Health Act does use language that indicates that the board can inquire into whether the patient meets the prerequisites for involuntary status. If you haven't already, I recommend that you just take a look at the board's reasoning. Imagine this issue might continue to pop up, and it's interesting to look at and decide. So, in terms of the cross-examination, I will be playing the psychiatrist. I had a plan to wear a stethoscope, but couldn't find one in time. Mitchell will be the applicant's lawyer. Keep in mind, we are making a few things up as we do not have the actual evidence in this case, but it still will be illustrative. Just for any of you that don't know, to situate the cross-examination, it would come right after the doctor has given their evidence and right before the board asks its questions. You usually have a right to re-examine based on the board's questions, but we're not going to be doing that today. So whenever you're ready, Mitchell.
Good evening, Dr. Ahmed.
Good evening.
Thank you for your evidence. I heard, if you could, do you have the Form 3, the Form 30, and the Form 50 in front of you? They were made exhibits earlier today.
Yes. Do you have page references for me to look at for
13, 16, and 22.
Thank you for having those ready, Mr. Rowe. Yes, they're in front of me.
Now, the Form 3 is the Certificate of Involuntary Admission. Of course, it's dated September 8th. You have that?
Yes, correct.
And the Form 30 is the notice to patient of the Form 3, and that's also dated September 8th, correct?
That's correct.
And the Form 50 is the confirmation of rights advice. That's also dated on the 8th of September.
Yes, I see that too.
Okay. Now, it's actually the resident, I noticed, of your hospital that completed the Form 3, correct?
That's correct.
All right. And so it wasn't you.
No, I am not the resident.
You've had contact with MTA, have you?
Yes, I saw her this morning just to make sure that she had access to the Zoom.
And you agree with the opinion set out in the Form 3 by the resident?
Absolutely.
All right. Now, on the first part of the Form 3, it's certified that MTA has been found incapable of consenting to treatment. You see that?
Yes,
Okay. She didn't challenge that finding, I understand, correct?
no, she has not challenged that finding.
But I see that the chart indicates that this assessment or this finding of incapacity was made on September 10th, 2 days later. Do you see that?
That's what it says, Mr. Rowe.
And it appears that this assessment was done rather quickly. It says, and I quote from the September 10th note, that it was from 1800 to 1805. That's 5 minutes. Do you see that, Dr. Ahmed?
Yes, that is true, but that does not mean a proper assessment was not done.
One would say it was rather quickly done. Would you agree with that?
Perhaps.
Now, there's no other evidence of a capacity assessment that I could see in any of the evidence that you brought to the hearing today. So this is the only assessment, correct?
This is the only assessment, correct. However, I do have other evidence of capacity, which I just shared in my opening statements.
We'll get to that. I also see from your CCB summary that the substitute decision maker is MTA's sister. That's correct.
Correct, yes.
And I noticed that also from the chart that the sister was not contacted about this until September 10th. You see that in the note?
Yeah, I vaguely recall speaking to her before that, but yes, that's the first time it was charted.
You vaguely recall speaking to her, but you don't have anything in the chart other than what was in the September 10th chart.
That's correct. There's nothing else that was written down.
Okay. I don't see anywhere in the September 10th note regarding the conversation with the sister that any of the prior wishes of MTA, if she had any, were even discussed. You don't have any information on that, do you? It's not in the note.
Well, I'll say this, Mr. Rowe, it's my usual practice to discuss prior wishes with the substitute decision maker. And even if I don't chart it, I do it in almost every circumstance.
You did say a minute ago, though, that you had a vague recollection. So you don't have a specific recollection. You're basing just on what you would normally do?
Yes, I have a lot of patience and I speak with a lot of substitute decision makers. I can't remember everything.
MTA has a mother. I don't see any indication that anybody tried to contact or speak to the mother. You didn't do that, did you?
There's no indication of it in the records. And again, I can't remember specifically, but
you're not aware that the resident contacted the mother either?
I'm not sure.
So you don't have any evidence that the mother would have consented to the treatment planned under the...
Correct. There's no evidence that she would have consented to the treatment under this form.
Now, if we look again at the second paragraph of box B, and the resident and with whom you agree has certified that MTA has previously received treatment for a mental disorder that, when not treated, likely result in a substantial mental or physical deterioration of MTA. Now, I know from the previous evidence that MTA has been admitted to the hospital 11 times since 2017. You agree with that?
Yes, she has a long history of being treated for her mental health issues.
And I see in your CCB summary that you say that when she's not treated, she'll suffer the substantial deterioration. But I don't see anywhere in MTA's chart that the actual notes from the previous admissions were received by your hospital. They're summarized. You've summarized them in the CCB, but I don't see the actual notes. I'm correct on that, am I not?
I must have reviewed them at some point, but often what's in the notes is often just what's most appropriate and efficient to present on this current admission.
You're not aware of anybody else in the hospital, like your resident, for instance, of actually reviewing those, or receiving and reviewing the previous up to 11 admissions?
It's possible that they did.
Okay, but you don't have any information?
No information.
Okay.
No.
Would you agree with me that were the board to see the actual admissions, both the treatment received and also the diagnosis of these admissions would be a more reliable and would give a more reliable and fulsome picture of the previous admissions, Doctor?
Certainly, I would agree with that idea, but there's a lot of things that could give a more fulsome picture of what's going on with MTA. I've only included what I thought was most relevant, which I believe is the most efficient use of the board's time.
Well, I asked these questions with respect to the previous admissions because in the third criteria under box B, in the form 3, there is a requirement that MTA had shown some sort of improvement, a clinical improvement from the past treatment. And so I put it to you that well, it's questionable to conclude with any high degree of certainty how she was treated in the previous admissions when you don't have those original admission notes. Do you agree?
I suppose not with the evidence that's before the board today, but I am summarizing what I read in her history and my own testimony, and CCB summary summarizes all of that.
Do you find it unusual, Doctor, that MTA has had 11 admissions since 2017? Can you really conclude that the past treatment has improved her mental health?
It has, I believe it has.
And you're not capable of saying what treatment she had during those 11 admissions because we don't have those notes. Is that true to say?
Well, she was discharged, and I cannot say it off the top of my head right now.
So the schizoaffective disorder was the bipolar type, was the diagnosis that your hospital made at her admission. But you can't say that that diagnosis was the same diagnosis as she received on the previous 11 admissions, can you?
I cannot say for certain, given the evidence before the board, but again, I did read the previous medical records, and I recall that the previous diagnosis was similar, if not the same, as the current admission.
Now, moving to the next part of the box B criteria, which has to do with the likelihood that she'll suffer substantial mental or physical deterioration. Is it your opinion that MTA's history shows that she will substantially deteriorate if she leaves the hospital before treatment?
Yes.
Now, she's presently on a community treatment order, correct?
That is correct.
And so, and out of that, she must attend monthly for injections, antipsychotic meds, right?
Correct.
And she's never failed to attend for the injections.
Not to my knowledge.
And she's never had a Form 47 order for examination issued to bring her in for an injection, correct?
Again, not to my knowledge, no.
So I suggest, Doctor, that the treatment that has been ordered by the CTO, by her previous psychiatrist, and which she could have outside of the hospital, this treatment, not inside as an involuntary, but outside of the hospital, would be sufficient to ensure that there would be no further substantial or no substantial deterioration. Can you agree with me on that?
No, I would disagree. I would say, based on my recent observations of her and in my clinical opinion, that her mental state has now worsened to the point that she will deteriorate outside the psychiatric facility, especially given her lack of supports on the outside and her worsening hallucinations telling her that she should self-harm and destroy property. I mean, Mr. Rowe, these are terrible things that she thinks, and it's only getting worse.
And the community treatment order cannot deal with that as it had before,
No, not in my opinion.
in your opinion. It's your opinion that she's not suitable as a voluntary patient?
That's correct.
I noticed on the Form 3, it's been signed at the end by somebody, and correct me if you look at it, it looks like a Dr. Doogie Hauser. Is that somebody at your hospital named Doogie Hauser?
Yes, that is someone at our hospital, Dr. Hauser.
Are you telling the board that an individual who's been given the important position in your hospital of officer in charge is named Doogie?
That's correct.
All right. Now, if we could turn to Form 30, that's the notice to patient. Doctor, I guess on behalf of the resident, you're able to confirm that this Form 30 was given to MTA at the time of the Form 3?
Yes,
It's dated September 8th, so you can confirm that.
I can confirm that.
Now, the Form 50, of course, is what the confirmation of rights advice. That's what MTA received from the rights advisor, and that's also dated September 8th. That's part of the exhibit list, correct?
Is it dated September 8th?
Yes, they're all dated the same date.
Yes, then I suppose it is.
Yeah. Now, would you agree with me, doctor, that the purpose of the rights advice is to give the patient some opportunity to speak to somebody about their dilemma or their admission that's not part of the hospital?
That's part of it, certainly.
Well, that the person isn't part of the hospital. The rights advisor is separate and distinct from the hospital. Get an outside opinion.
That is part of the reason why rights advice is
Okay.
given.
So,
Agreed.
and then the notice sort of refers the rights advisor to the Form 3, which has the criteria of this of the concern that the patient will suffer substantial mental and physical deterioration. So she would have received the rights advice on that issue, correct?
I'm not sure what the rights advisor would have told her, but purportedly, sure.
Well, there's been no. You're aware that on the Form 3 there's no criteria in box A ticked off.
Yes.
And the only criteria ticked off in box B is the suffering of substantial mental and physical deterioration. So that's the only thing that the rights advisor would have focused on. Would you agree with that?
Again, I'm not the rights advisor, but perhaps, yeah, you might be right.
Now, your resident could have ticked off any number of those boxes, correct? But they didn't.
No, clearly.
Okay. Now, would you agree that that to receiving rights advice on specific criteria would necessarily focus?
Oh, sorry, hang on one sec. I will
Okay.
mute everyone. Just bear with me. I don't know who that is, but let's see. Okay, I think I've resolved it. My apologies.
Well,
Sorry, Mr. Rowe, go ahead.
that's okay. You'll agree with me that individuals such as MTA in the hospital are in a vulnerable position, at least feel that way. Would you agree with me?
Of course.
And that's why rights advice and the talking to somebody who feels independent of the hospital needs to happen promptly.
Yes, part of the reason.
Okay. And in this case, MTA, her sister or her mother, nor her sister, or her sister nor her mother were consulted. Correct?
Again, I can't remember exactly, but as for the evidence before the board, you're right.
Would you agree with me that it's unfair for MTA to receive rights advice on one particular criteria, the substantial deterioration criteria in the form, but then at this hearing, have the board or your hospital rely on other criteria that aren't included in the form? Would you agree that that's unfair?
I'm not sure if it would be unfair. I think it would be equally unfair to nullify an involuntary status finding, even though she meets the box A criteria, just because of a technicality like that.
Rights advice is not a technicality. Would you agree with me on that, Doctor?
I would agree with you on that, but I do believe that the grounds can be explored at this hearing, both box A and box B.
Would you have any concern that when I say that she didn't receive proper notice because of that? Because of the reliance on other criteria in the form rather than the sole one ticked off?
Perhaps you're right, but I still take the position that both grounds may be explored at this hearing.
Thank you, Doctor. Those are my questions.
Thank you. Okay, great. Mitch, if you can, could you just describe the general strategy you were using when questioning the doctor?
I don't want you to talk very much. I just want you to say, yes, I agree, correct, yes, okay, that's it. If I ask too many open-ended questions, then you're going to go on and you're just going to repeat everything you've already said. We didn't hear, of course, but you already said in chief. And I don't need that. I mean, you're just going to go all through and highlight again all the stuff that's in the CCB summary or the chart or any of the other exhibits. So I really don't want you to go there. I want to try to narrow things down as much as possible. We had in this case a couple issues. One was that I would bring up in the submissions. One was a lot of stuff that you said wasn't, the doctor said wasn't charted. And if it's not charted, there's the Evidence Act, Section 14, says you've got to have it corroborated. So I tried to say, I mean, that it was all in your CCB summary, which you didn't have specific reference to any of the original chart notes. So that was one issue I would talk about in submissions. The capacity assessment coming after Form 3 was the obvious one, and the court, or sorry, the CCB said in their decision that they wouldn't have certified under the box B criteria because of that, and also because the substitute decision maker consent was received after the Form 3 too. So those two issues sort of killed the box B requirement. So I just had to focus on those. Now, as we know in the case, they just said, okay, well, let's look at box A. She had, how many did I say? 11 admissions. There was evidence that the box A criteria were fulfilled, some of them. So I just tried to keep things as narrow to those, really my three issues was the charting, the SDM, and the capacity assessment coming after.
And I thought it was really good. I don't think you asked one open-ended question. I may have been wrong.
You did. So I'm here to pick on him for that. But I popped in here just to say a couple of things. So first, in part 1 to this series, some of the things you heard about today are also covered slightly different perspectives. So there are some cross-examination tips in part 1, and there's some client relationships. A lot of the stuff that Michael Schloss talked about is also covered in part 1 in terms of preparing for hearings generally with respect to your client. You heard more particulars today about involuntary admission. but let me congratulate Mitch on the demonstration cross-examination. It was very gratifying to hear a proper cross-examination with 95% leading questions that were so a leading question, of course, suggests the answer, leads the witness to the answer, and they are not open-ended questions. And I want to congratulate Shanil as well for being a typically evasive and condescending, arrogant psychiatrist, as a typical witness would be, and giving responses like, I would consider it a greater unfairness to let someone who's very sick go. But I wanted to ask Mitchell, and I know he'll be glad that I popped in, whether in retrospect he would ask that question. There are two questions toward the end. One was, do you think it's unfair, or would you agree that it was unfair to do this or that to the patient, to not provide them rights advice on one issue versus the other? Because in the end, he told you, I wouldn't say that that was unfair. So in retrospect, is that the way you would ask the question again, do you think?
Well, I want to bring it up to the CCB. I want them to, I don't want, my client's probably not going to testify with 11 admissions in the last 5 or 7 years. I doubt if they will, but I want to at least bring the idea forth that it's just not fair to rely on the A and B. Recognizing, Anita, that the case said you could, ultimately. But at the time, I guess if I try to put myself before that, then I want them to say, I want them to think, no, it's not fair that that A isn't all of a sudden in the picture.
So I guess my question arises from, do you have to ask the doctor? Because he's not going to give you what you want. He's going to disagree with you. Or is that something that, based on the evidence you do have, rights advice was provided one thing, but not the other thing, you can simply make as a submission?
I agree.
At the end of the day, because that's, personally, I'm always afraid to ask these questions. And the impulse is there for all of us. Let me mute everyone again, because we have new people coming in all the time. The impulse and the compulsion is there for all of us to sort of ask the important conclusory question. You lead up to, and then you want to say, well, that's a gross unfairness to my client. You're going to have a physician say, no, it isn't. The real unfairness is busting the sick people loose on the street, right? And then that's the last thing that they hear. So, but with that kind of thing, knowing they're going to not be helpful to me, I would personally save it for submissions. And of course, the overall context is the board's never going to care, but that's not the point. We're there, and for our client to hear you ask the question is important, right? This was really an unfairness to this person. So if they're sitting there and they're hearing it, that's important. And then your very last question, and now I forget what it was. Oh, you said, would you have any concern, doctor, if I suggested that the patient wasn't provided notice as a result of this? So I think that's another thing where you can just either bark at the witness. So my client got no notice of this thing, and see what happens, or save for submissions. So I was just here to nitpick because I can't help my.
I think I agree. I mean, I think I agree. There's lots of things where all you really need to do is get the dates or the order or what the info is, and then stop. And then because if you ask one question too much, then it gives the doctor, in this case, the opportunity to explain, and that can make you lose that point. So I agree. Sometimes you go too far.
But I think in this case, it's not going too far, in fairness to you. And I think why it's important to establish an unfairness, a lack of notice, a failure to provide rights advice. One of your really great questions was, he was like, oh, these technicalities. And you were like, rights advice is not a technicality, right? And even he had to go like, yeah, okay, on that. But if there's something that I haven't read this case in a while, although I wrote about it quite a bit somewhere else, because it's I think one of the sort of biggest, can I say clusterfuck here? I think I can. It's just us. Like, it really is a disaster in terms of what they've done to the law and to the clients. So I think this case is significant for how awful it is. And I don't remember now whether counsel to the patient in this case specifically asked that they rescind the involuntary status of the individual, notwithstanding that the criteria may be met based on some egregious procedural abuses, which I think may have been open to them. So that's something we didn't cover in this session, but I think we will cover later in terms of preliminary issues or other complex litigation before the board. Because I think, as we all know, if the criteria, someone named Anita Law is entering, and that's just freaking me out because it's not us. Of course, with these types of applications, I keep having to mute everyone. If the criteria are not met, the board must rescind the certificate. But if the criteria are met, they may confirm or uphold the certificate, right? So there is that little wriggle room for where the criteria may be found to be met, but the board can still rescind the involuntary status. And that's under, it's an option where there's been significant procedural unfairness, or some action by the hospital would make it unfair to uphold an involuntary admission, notwithstanding the statutory criteria. So I think all the points that you made, Mitch, were really good. I think this was an excellent, really superb cross-examination demonstration, both for sort of how typically they would go in terms of how the witness would respond to these types of questions, and also because Mitch cross-examined the doctor properly, as a cross-examination should go. If you review part one, the intro that Shira and I did, you'll see, and I repeat my frustration with reading transcripts from consent and capacity board hearings where patients' counsel think that these are therapeutic proceedings and that you have to be incredibly deferential to the doctor, and that means that you can only ask open-ended questions, and you have counsel to patients starting their cross-examinations with, "Doctor, can you tell us a bit about the symptoms my client has? Or tell us more about, his meds, and what do you think would be best? And how long do you think they should be in hospital, really, before they're better?" And I can't, I lose my mind. So here you witness what you ought to be doing. And thank you so much, Mitch and Shanil, for doing this. I'm watching the chat. I haven't seen any questions in the chat. If people can unmute themselves if they have a question, that's fine. If the Michaels are still with us, I did want to give them an opportunity to see if they, or you, Mitch, or Chanel, if anyone has some other comments to make about things that maybe came up, but remain unclear. I wanted to clarify, Chanel, because I popped in there to say both parties, all parties to these hearings have 30 days from the date of the hearing, I think, or from the date of the decision. I always forget, but that's one day apart, to make the request for the reasons for the decision. But the reasons for decision have to be delivered within 4 business days, I think.
Yeah, that's what I was thinking of.
That's what you were thinking of, from the time that the request is made, which is, of course, terrible. That was an amendment. It used to be 2 business days. The reason 4 business days is so bad is it makes it physically impossible for us to advise our clients about whether or not to appeal, whether the reasons are good or bad or appeal proof. We cannot practically take into consideration what the reasons say before advising the client about filing a notice of appeal. So we have to file them to protect their 7-day statutory limitation period. Because think about it. You have a hearing on Monday, the decision comes in on Tuesday, your client tells you request the reasons on Wednesday. You're not going to see those reasons until 4 business days, Thursday, Friday, Monday, Tuesday, the following Wednesday. By then, your statutory 7 days from the date of the decision, which was Tuesday, are gone. So it's almost physically impossible unless you ask in the hearing room in advance to get reasons, and then you might have 1 day with the reasons at most before you have to decide whether or not to appeal. So it's not a functional appeal system. Does anyone know if Michael French is still with us? No, I see Michael Schloss there. Okay, he may have had to go. Any questions? Anyone? Does anyone have any questions? Anyone want to turn on their video, raise their hand? No questions?
I had one question. I had a hearing a couple of weeks ago where the doctor didn't show. There was just a mix-up something. And of course, on these voluntary ones, they're banged up in the hospital for 14 days. We were at about day 7 or so. You rant and rave a little bit about an adjournment, but of course, ultimately the board gives the adjournment. We got it to the day prior to the 14-day end of the form, and the day of the hearing, the Form 5 came in. So really, ultimately, they were just kept in the hospital for, I guess, 13 out of 14 days. There's a rule, I guess. I didn't know it at the time. I guess there's a rule on the board procedure, but you can rant and rave, but I gather you're never really going to succeed unless maybe your hearing is on the last or second last day of the form. Is that correct?
That you're not going to succeed in what?
In moving the client, in moving the hearing forward and having the form dismissed or rescinded.
Based on no show? Based on
Yeah.
no show? So there are two, it's in the book. Because I try to focus on it. I think Crystal Francis is with us, and I think she did one of them. There are 2 cases where the board rescinded involuntary status of the patient based on no show by the doctor and no evidence filed. If I'm not mistaken, in both cases, this was a repeat offense of some sort. Either the doctor had pulled his son before with respect to another patient, or this happened the second time after they adjourned on the first occasion to allow the doctor to show up. One of them specifically was like nobody came. So the doctor went on vacation and had responded when they scheduled the hearing. I think it was Dr. Tugg, actually. I think I remember he like wrote and said, I'm on vacation, so I can't make it or something, and then didn't do anything else about it. And the board rescinded the involuntary admission because they said despite knowing he would not be able to attend, he went away. He didn't prepare a summary. He didn't arrange for a colleague to attend to speak to it. He didn't do anything. So in the whole history of the entire world, it's happened twice that there was success. So it's really unlikely, like obviously 99.9% of the time they will adjourn. But I think if it happens again, if it's clear that the doctor is simply refusing to participate, because our office did face that as well. We had a psychiatrist who was just like refusing to participate, no matter how many times we came back. So, but I think you're right. Practically speaking, it doesn't mean you shouldn't make the motion. It's the doctor's onus. If they don't bother being there, they've had notice. It says on the notice, we may proceed in your absence. So good on you for making the argument. But yeah, we generally find they're very deferential to the doctor. Okay. Shira? No, you're on mute, love. You're muted. Oh, maybe I muted you. Hang on. What's happened? Why can't I unmute you? Try and unmute yourself.
I'm unmuted on my computer.
Oh, there you go. Now we can
hear you.
There
Okay,
you
good.
go. Just took a second. Did you have a question?
Yeah, I've experienced a few times where my clients are given, or we receive Form 5s for our clients. Then I call my clients, they have no idea they've been given a Form 5. And my usual advice to my clients then is they should leave, because if they wanted to get out, because if the doctor did not inform them that they are now able to stay as an informal or voluntary patient, then that's quite problematic. And it kind of also puts it to the test for the doctor to put their money where their mouth is, if the patient is actually voluntary, or if they were issued a Form 5 in theory that wasn't even provided to the client. So I wanted to ask what advice you would give to clients when they receive Form 5s. So that's number one. And number two is, if you have a client that's been in the hospital for a period of time, they were formed initially, then given a Form 5, they remained in the hospital and then subsequently formed again. How do you address that?
I disappeared to let you guys answer the questions.
Oh,
I was going to say, I like the idea of telling them to leave. I haven't faced that scenario yet, but that might be one. I like that idea.
well, on the, sorry, Shanil, on the
Go
one
ahead.
that I had a couple of weeks ago, I phoned the hospital because you always got to check up on the Form 5 for that very reason, Shira, and the patient had been discharged the day before. So I think you should always check that the patient knows that they can leave whenever they want, just in case they haven't been told. I don't
Any
remember the other part of your question, Shira.
Yeah, I was going to ask.
The other one was, if we have clients that have been in the hospital, they were initially formed, then issued a Form 5, and while they were staying as a voluntary patient, subsequently formed again, how do you deal with that?
So, I mean, in theory, like the law allows for a voluntary patient, as you know, to be converted to an involuntary patient in some circumstances, right? So you can, but I think, I mean, sure, I could be wrong, but I think what you're asking is if you suspect a pattern of abuse by a particular physician, where they will issue Form 5s, changing your client's status from involuntary to voluntary to avoid a hearing on the issue. And subsequent to the hearing date passing without your client exercising a right, the client finds themselves back again on a form. There are, a few things you can do in that situation. While this board tends to defer to physicians and medical professionals over our clients institutionally in a, I think, potentially biased way, they are actually very sensitive to patterns of abuse of their processes. They are aware because they are on the receiving end of all these Form 5s. So they can see the patterns when a particular doctor issues a Form 5 the night before or the day of a hearing that's been booked. And it inconveniences the administrative duties of the board. And also, I think they are genuinely concerned about procedural unfairness and abusive process. So you can bring this to their attention. So not often, but a few times in my career, I have written to the vice chair or the chair of the board and obviously copied the physician who is a party, because we don't write to the tribunal without copying the other parties, to say that I am concerned that my client so-and-so has had a hearing of the board scheduled on this date and this date to review their involuntary status, that they were made a voluntary patient the night before the day of the hearing on each occasion. And I am advised that they were reformed the subsequent day, for example. And there is a case, it's called, I believe, SH. It goes back to 2002 or 2003. I remember it very clearly because it was one of the first cases I did with my then new law partner, Darcy Hiltz, who was a previous vice chair of the Consent and Capacity Board for 20 years. And it was a decision of Phil Capel, and it's still valid today. It was a very important case. What happened there was that vulnerable people at CAMH, people with dual diagnosis, cognitive impairment, and mental illness, were held on a particular unit, a dual diagnosis unit. They were all in restraints. They were on a triple locked unit. They had helmets, waist wrist restraints. They had behavioral issues where they banged their heads and so on. And they were super vulnerable. So they never themselves exercised the right to apply to the board for a review of their involuntary status. So their only procedural safeguard was a mandatory then annual hearing because you didn't have the post PS every 6 months. There was a doctor who was in charge of that unit at CAMH who routinely and in every case wrote a pretend Form 5 the night before these mandatory hearings came up for these vulnerable individuals. There were like 25 patients who never got a hearing. They never got their once annual mandatory hearing. And this pattern was brought to our attention. We argued the pattern. We brought the CEO of Canada's largest psychiatric facility by subpoena to testify. And the board was extremely incensed and agitated. Use that provision we were talking about to rescind our client's involuntary status, and had a lot to say about the abuse of power by this particular doctor over these individuals. And that was a really big win and a very good news story, I thought, for vulnerable people. Until the institutional response to that case was to no longer certify any of those patients ever again. So dual diagnosis patients have since languished as pretend informal patients whose substitute decision makers supposedly give consent to them being held against their will for treatment on that unit. So instead of fraudulently removing their right to their once annual mandatory hearing of their involuntary status, they simply were never afforded any due process reviews of their detention and restraint again. So that was a very hard pill for us to swallow and lesson to learn. And I'm sorry to give you the bad news at the end of the day, but the point is there are cases where the board has commented on abuse of its processes, and you can do that, and they will convene very quickly. So you can say to them, this is the third time my client's been put in a Form 3 after a Form 5, and the board will get you a hearing very quickly. Does that respond, Shira, to what you were asking? Maybe ask a completely different question.
No, that is helpful. And perhaps this is also something to raise at the preliminary issues session, but that's something also, would you raise that as a preliminary issue?
That's a really good question. I mean, I think you could. I think if you did raise it as a preliminary issue, you might have to, on the preliminary issue, file the chronology, like set out the chronology clearly, and you may have to file all of the charting notes between the time of the Form 5 and the new Form 3 to establish the absence of a material change in circumstances, because the only thing that would save the doctor in such a case would be that something happened, because they can be of the view that your client's suitable to be voluntary on Thursday night, but if Friday morning your client, beats up a co-patient, puts them in a coma, they end up in seclusion, I think there's an argument to be made that a Form 3 was appropriate in that case. But if absolutely nothing happens and there's a note from the doctor saying, Form 3, Form 30, then I think you can try to do it preliminarily, and the doctor will be asked to respond. Yeah, I mean, there's no downside to trying to do it preliminarily. Everyone knows why you're there if you set it out in writing as to why you want a quicker hearing, for example. I don't know. I feel bad though, because we've kept people past 7:30, and it's actually entirely my fault that I've done that. But thank you, Shira, for that question. Any last comments? I've lost Michael French. Any last comments? If not, I'm going to ask everyone who's able to please turn your video cameras on so I can take my picture for hi, Crystal. And then I'm going to ask the panel members and Shira to stay with me afterwards for a discussion that we said we would have after every event. But look at everybody's faces. This is lovely. Okay, thank you so much. So what should we say? 1, 2, 3, paternalism? I don't know. Can't think of anything good. 1, 2, 3, cross-examination. Yay, that's 1. And then let me see. Let me take another one, move my screen. Get everybody. Okay, ready? 1, 2, 3. Michael French, where is he? We don't know. We lost him. Oh no. Okay. I think I've got everyone. I apologize. Some people say they're prevented from opening their camera, but I know from last time that that becomes like an effective impossibility to rectify. I think that was technical. Well, thank you everyone for coming. Have a good night.
Thank you, everyone. Anita, it
Danielle.
is still
Thank you.
recording.
Oh, yeah, sorry. Thank you for letting me know that I always forget.
No worries.